Oh, right up the nose. Let's get ready, shall we? I am gonna do some makeup on my face. I'm not a makeup artist though, so don't get it twisted. My name's Leja. I'm a real life lawyer on a mission to demystify the law and how it affects your everyday life. But I want to combine doing my makeup with talking about an iconic case from history. 2 disclaimers. 1, I'm not a makeup artist. I am a lawyer. And 2, I'm not your lawyer, and none of this should be construed as legal advice. Today, I want to talk about Roe v. Wade because it's iconic, it's still important, and it's being threatened every single day. I feel like most people kind of know generally that it's about abortion, but do you really know the backstory about it and kind of what the court actually determined in the case? Maybe not. So, you know, watch this video and then you'll have a lot of really impressive things to show off to your friends about your personal knowledge. I will say that in making these videos, it is not my intent to make light of the case that I'm talking about, because a lot of cases, especially the really iconic ones, deal with pretty intense subject matter. But my real goal in making these videos is just to make these cases a little bit more accessible and maybe told in a more entertaining way. So that's my intent here. So Roe versus Wade was decided in 1973 by the US Supreme Court. However, there's a lot more backstory where that came from, and I kind of want to back up quite a bit. Luckily for all of us, the opinion, that is the decision that the court made, one justice from the Supreme Court is chosen to write the opinion. Luckily for us, Roe versus Wade's opinion was written by Justice Blackmun, who had frankly an iconic forehead. He delves into the whole history of abortion in the opinion. So I luckily didn't have to do much of any research when it comes to that because he did it for me, or more precisely, his clerks did it for me. Fun fact, most judges don't actually write their opinions. Their reasoning and argument is original from them, but the research and actual writing of the opinion is usually left to clerks who are usually current or recent law school graduates. Maybe you didn't know that. Now you do. So Justice Blackmun's clerks did some great research on the history of abortion so that I don't have to. So let me tell you about it. So the opinion goes all the way back to the Greeks and the Romans. And apparently in Greek and Roman times, people were really chill with abortion. Turns out. But then you got Christianity. They come in, they take over, they're not cool with abortion. It doesn't actually say anything about abortion in the Bible, but people read the Bible as kind of valuing human life from conception and basically say that it's not up to our own will to determine kind of when life starts or to determine when it's okay to end life. That's the gist of my understanding of it. After the Greek and Roman times, then came kind of the rise in Christianity, abortion, less chill. Then the court jumps to early English common law. Common law is just court-made law, so like judges' opinions. English common law is where a lot of US law is derived from, so it makes sense to look at kind of where England was in the early development of English common law a few hundred years ago. English common law tended to look at the idea of quickening, which was when there was like fetal movement, like you could actually feel movement, and it was said that that was kind of an indication that life had begun. And in English common law, having an abortion before quickening or when movement begins was not a crime. So here, even though, you know, Christianity obviously was well established at that point, people were still pretty chill with abortion, at least before, you know, life begins, which is a question that no one's really answered, and we'll get into that in a little bit. So then colonizers came to America largely from England, and so they brought over English common law, and a lot of our law that exists now, at least the common law, is at least derived from English common law, because that's what we had to work with. So again, this idea of quickening came over to the United States, and, you know, abortion happening before quickening not being a crime. But then the idea of quickening began falling out of favor, and abortion started to become a bit more taboo, and penalties started increasing for performing abortions. Scholars say that this is partially due to after the Civil War, there was kind of these Victorian ideals of promiscuous sex and not wanting to encourage it by allowing abortions. And there's also the fact that antisepsis, or like not getting infections when getting a medical procedure, hadn't developed yet, so the likelihood of mortality during abortion was pretty high. So partially these bans and restrictions and penalties were because of the high mortality rate and danger of abortions at the time in, the late 1800s. So basically all this to say that at the founding of America, abortion was still pretty chill, and anti-abortion laws and outright abortion bans are quite new, and were especially quite new at the time that Roe v. Wade was decided. Like, they were a creation of the last century, basically. So that's like a backdrop to the different ideas that people had in, current and more ancient times. In the lead up to Roe versus Wade, there were a number of Supreme Court cases that were, I think, useful in the court being able to come to the outcome that it did with Roe v. Wade. And what I mean by that is that there was a number of court cases out of the Supreme Court before Roe v. Wade that developed the idea of personal privacy as a fundamental right that's protected under the Constitution. So the Constitution actually does not mention privacy at all. There's no explicit privacy right granted under the Constitution. However, a number of court cases have come around where judges have basically found that there is a right to privacy kind of implied from the Constitution and the Bill of Rights. The fancy language for that is that privacy is a fundamental right under the penumbras of the Bill of Rights. So some of the really important cases that came before Roe v. Wade that kind of helped set the stage were involving things like the right to privacy in who you marry, which is in Loving versus Virginia, which was a case involving an interracial couple. Also an iconic case that I would love to cover in one of these videos. There was also found to be a right of privacy in procreation, which was found in a case called Skinner v. Oklahoma. And it was found before Roe v. Wade that there is a fundamental right to privacy in choosing whether or not to use contraception. And that case was called Eisenstadt versus Baird. There were other cases, but those are kind of the three main notable ones that I wanted to highlight, because it's important to understand, or at least know, that there were precursors to Roe v. Wade that kind of paved the way for the court to be able to say, well, we found that there was a fundamental right to privacy in these cases, so it's easier for us to find that there's a fundamental right in abortion. Because, if there's a fundamental right in marriage, in contraception, in procreation, it's easy to see how you could get from that to finding that there's a fundamental right in abortion, because that's, the choice not to procreate. Okay, so that kind of sets the stage for Roe v. Wade. So now let's look at the parties in Roe versus Wade. Names like Roe and Doe as a last name are used in cases where the privacy of the individual, in this case the plaintiff, it's an abortion case, it's highly sensitive. Anytime when there's sensitive subject material or privacy is at issue, people can use last names like Doe and Roe to maintain their privacy. So Jane Roe is a woman named Norma McCorvey. This obviously was not known at the time that Roe v. Wade was being argued. It wasn't publicly available information that Roe was this Norma woman, but it came out afterwards, and so we're able to know quite a bit about Norma's life, and honestly, it's pretty shocking to read what her life was like. Like, she had a pretty hard life. She had an alcoholic mother, her dad sounded like he was pretty absent, and wildly, at the age of 10, she robbed a gas station and then ran off to Oklahoma City from Texas, where she lived, with a friend at 10. And then was found and brought home and was sent to like some reform school. But she married at 16 and her husband was abusive. She had one child with him and then had another child who she put up for adoption. After she separated from her husband, experienced a lot of alcoholism. And I'm not saying that this is like a typical profile of someone who seeks an abortion. What I am saying is that you don't know the typical profile of someone who seeks an abortion, and so you shouldn't judge a book by its cover. Norma had a really hard life. So at 21, she was unwed and pregnant again and was just not in the right state to be having a baby, and so she wanted an abortion. This was in 1969. So then she gets referred to a couple attorneys by the name of Linda Coffey and Sarah Weddington. Sarah Weddington was 26 when she argued this case in front of the Supreme Court. Like, who does that? She graduated from law school at 22, and then by 26 was just casually arguing in front of the Supreme Court. Pretty badass. So Linda and Sarah were both cause lawyers, and cause lawyering is basically where you have a cause or an issue you're interested in. You try to find plaintiffs that you can represent to help push the courts to make determinations to help further your cause. This is really common. It goes back a really long time. Cases as old as like Plessy versus Ferguson were cause cases. It happens on kind of both ends of the political spectrum, if you want to think about it like that. It's just a way to be an activist as a lawyer. So Linda and Sarah, they were activist lawyers. They wanted to get bans on abortions declared unconstitutional. So they were seeking women who were pregnant and wishing to get abortions so that they could represent them in court to try to get specifically this Texas ban on abortions declared unconstitutional. The Texas statute at issue banned all abortions unless the life of the mother was seriously at risk, and Linda Coffey and Sarah Weddington argued that this was unconstitutionally vague and also unconstitutional under the 1st, 4th, 5th, 9th, and 14th Amendments. Basically, when you're trying to make an argument that something's not constitutional, you might as well throw as many noodles against the wall and see which one will stick. So in 1969, the two attorneys agree to take on Norma's case. She becomes Jane Roe. Norma McCorvey didn't actually attend any of the hearings related to the case, and she actually ended up having the baby before the case was decided because the case took 4 years. And, you know, babies take 9 months. So she ended up putting the baby up for adoption and didn't even get to benefit from Roe v. Wade in the end. So the case started in 1969 but didn't end up being decided until 1973, which is pretty typical. Cases take a long time in our system to get through. Before getting to the Supreme Court, the case was in the district court in Texas, and the plaintiffs in this case were seeking a declaratory judgment as well as injunctive relief. The declaratory judgment, they were seeking to have the court declare that this law was unconstitutional before someone like Jane Roe, Norma McCorvey, would actually be prosecuted under it. So it's basically a preemptive move to try to get a law declared unconstitutional before it can cause harm to the plaintiff. And then injunctive relief is asking the court to enjoin a party or to basically tell a party that they cannot act in a certain way. And so in this case, they were suing Wade, who was the district attorney in Texas, to enjoin him or stop him from enforcing this law because it was unconstitutional. Now, Jane Roe was actually not the only plaintiff in this case. She was one of 3 kind of parties. So besides her, we also had Dr. Halford. Is that his name? Yeah. And he was actually already being prosecuted under this law in Texas, and so wanted to be joined to have it declared unconstitutional, obviously, so he wouldn't be prosecuted under it. And then we also had Mr. and Mrs. Doe, who were a married couple who were not yet pregnant, but were not in a place where they wanted to become pregnant and have children, so they wanted to be able to have an abortion in the future should they want to. And so they wanted to have this law declared unconstitutional. The doctor's case ended up being dismissed by the Supreme Court because they basically said, you're already being prosecuted under this law. You need to be arguing these constitutional arguments at the court where you're being prosecuted, not in front of us. Then Mr. and Mrs. Doe's case was also dismissed because the court said that they didn't have standing. Standing is basically your ability to bring a case because you're actually suffering a real harm that a court could actually address in making a decision. And in order to have standing, the harm that you're suffering can't just be speculative. And in Mr. and Mrs. Doe's case, it was really speculative. They were just saying, well, in the future I might want an abortion, so I'm suing. You can't just sue because you might get prosecuted under a law at some point in the future. You have to actually have an addressable harm that the court can actually provide relief for. So ultimately it was just Jane Roe who was part of the case, and you might be wondering, well, okay, but then she had the baby, and then by the time it even got to the Supreme Court, she wasn't even pregnant anymore. So would she even have standing? And they did talk about this, and determined that, first of all, it wouldn't be fair not to find that there was standing just because the gestational period of a human is too short for it to get through court, but also the, I guess, danger or what have you of becoming pregnant can reoccur in the same woman, and so the same injury is always a potential. Because of this, because of the potential of reoccurrence of the injury, she still had standing to bring this case. What am I doing? What's next to go on my face? Blush? What have I done? Let's do blush. Okay, so then we get to oral arguments in front of the Supreme Court. Apparently, on the first day of oral arguments, the attorney who was representing Wade, the defendant, started his oral arguments in front of the Supreme Court of the United States by saying, and I quote, "Mr. Chief Justice, and may it please the court, it's an old joke, but when a man argues against two beautiful ladies like this, they are going to have the last word." Apparently he was met by complete silence, and some of the justices basically just like stared him down. This was, mind you, before there was any lady on the Supreme Court, and even then it still did not get a great reception. So that was the first oral arguments. Then, because of some changes in justices and some other cases that were in process moving forward through the courts that had the potential to affect the outcome in Roe v. Wade, they decided to have new oral arguments for the case. And in that case, that first lawyer who made that opening statement, he was not the one who represented the defendants. So they clearly were not thrilled with his performance there. All right, so in the decision itself, what does the court argue? Obviously, we know that in the end, the court granted the right to women or people who are capable of carrying human life in their womb to get abortions, but how did they get there? So basically, I mean, they look at the history as I outlined at the beginning of this video, but they also then talked about the legitimate interest that a state has both in protecting the life of the mother on one hand and in protecting the life of the fetus on the other. And they reject this idea of quickening because it's kind of fallen out of favor, but they do decide that they are not in the position to make a specific determination of when life begins, because people a lot smarter than them, philosophers, theologians, throughout history have not been able to determine unequivocally when life begins, and that they are in no position to make that determination. So the court determines that the right to privacy that gives people the right to get abortions is encompassed under the 14th Amendment and the right to privacy that I explained earlier. However, the court also said that this right isn't absolute. Most rights aren't absolute. They have to be weighed against competing interests, and in this case, the right to have an abortion had to be weighed against the state's legitimate interest, again, in protecting the life of the mother on the one side and protecting the life of the fetus on the other. The court also looks at the definition of person within the 14th Amendment and throughout the Constitution and determines that nowhere in the Constitution is an unborn person recognized as a full person with full rights of citizenship. And that mainly the rights granted based on unborn children are because of the potentiality of life, as they called it. So the right in the potential that there will be life in the future. Absent an ability to make a determination when life begins, they decide to just be really technical about it and draw a line in the sand, because there really was no way for them to philosophically make a determination of when life begins, but they were able to logically kind of draw a line in the sand based on a state's legitimate interest both in the life of the mother and the life of the unborn child. So the courts determined that the state's compelling interest in the life of the mother starts after the first trimester, because during the first trimester, having an abortion was as dangerous, if not less dangerous, than actually just giving birth to a child. So there was no real legitimate reason why a state should be able to interfere with the right to have an abortion during the first trimester, because they clearly didn't have a legitimate interest in the life of the mother at that point, because the mother's life wasn't at risk any more than it would be if she were to actually give birth to the child. So that means that after the first trimester, states had a legitimate interest in regulating abortions, but during the first trimester, it was really up to the discretion of a physician in consult with the mother to determine when an abortion was proper. So that's the state's interest in the life of the mother, and then the state also has a legitimate interest in the life of a fetus, but not during the first trimester. And so the court had to make a determination of when that legitimate interest in the life of the fetus began, such that a state could actually regulate it. And the court determined that that interest, that legitimate interest, began at viability. Viability being time that physicians had determined a fetus could live outside the mother, at least, with assistance, but could viably live outside the mother's womb. So because of this, the court determined that the state did have a legitimate interest in the life of the fetus after it was actually viable, and so it could regulate after viability the ability of a person to have an abortion, except for when the life of the mother was at risk. And the court determined that viability was somewhere between 22 and 24 weeks, based on the medical research of the time. So ultimately, the court found that this Texas law was unconstitutional because it was too vague. It did not differentiate between the state's legitimate interest in the life of the mother and the life of the fetus after viability, and so it was unconstitutional under the mother's 14th Amendment right to privacy. Okay, so then what was the aftermath of Roe v. Wade? Norma revealed herself to the press shortly after the decision was made and went on to write a book called I Am Roe about her experience. But then, in 1995, she apparently met this evangelical pastor, is that what they're called? And he supposedly converted her, and she became pretty staunchly anti-abortion after 1995 and said she regretted her part in the Roe v. Wade decision and that she didn't think that abortions were okay, and she was a huge, can you imagine evangelical church? It was a heyday for them because they were able to say even Roe v. Wade doesn't agree with abortion. And pretty much immediately after Roe v. Wade took effect, states began chipping away at this idea of what a state's legitimate interest is in protecting the life of the mother and the life of the fetus. And so the Supreme Court has heard just a series of cases based on different types of statutes that states have passed in an effort to try to limit this right to abortion. And they've basically made a determination that a restriction on abortion cannot create an undue burden on the mother to seek an abortion. Some of these restrictions that are currently in place and that apparently are not an undue burden include things like spousal notification and parental notification prior to getting an abortion. There are laws that require that women or people who are seeking abortion receive medical literature that may or may not actually be medically accurate, and then they have to wait 24 hours before they can get the abortion, which for some people is quite burdensome because if you live far away from a clinic, you have to be able to find a place to live and stay overnight while you're waiting for that 24-hour waiting period, because you have to go and get a consultation and then wait afterwards. So I don't really know how some of these courts are coming to the determination that that waiting period isn't unduly burdensome, but they have found that it's not. And then also in some states, including the state of Minnesota, it's not considered an undue burden to have a juvenile have to go in front of a court in order to determine whether that juvenile is mature enough to decide for themselves whether or not they want to have an abortion or can have an abortion, which is wild if you think about that logically, because that means that if the judge determines that the person is not mature enough to make the decision to have an abortion, then that means that the person is mature enough to be a parent. Again, it really boggles the mind. It's kind of all just part of the larger trend of states just slowly, chipping away at the right granted to them to people under Roe v. Wade. And then also in response to Roe v. Wade, a lot of states enacted what are called trigger laws, which are bans on abortion that will take effect should Roe v. Wade be overturned in the future. Also, there's a lot of state laws that were never changed, so they still have abortion bans on the books. They just aren't enforceable at this point, but they would become enforceable should Roe v. Wade be overturned. So RBG has actually criticized the Roe v. Wade decision, saying that there was actually a movement happening in legislatures where laws were being changed slowly but surely, lifting bans on abortions, and she believed that it would have been a much more effective way of legalizing abortion, because it would mean if it's being done by the legislatures, it feels more like it's coming from the people as opposed to coming from a judicial, mandate. And so because of this decision in Roe v. Wade, there was such a huge backlash because the people weren't really ready yet for such a dramatic change. She also says that so much of the opinion is actually not woman focused at all, and it's actually very physician focused, because it doesn't really determine what's right for the woman, it just determines whether or not the physician should be able to make the determination, or if it should be the state. So it kind of overlooks the woman entirely, or, you know, in modern, you know, terminology, the person who can get an abortion, because not everyone who can get an abortion is a woman. But by the end of her life, and this was actually in an FX documentary that came out this year, though Norma died in 2017, RIP Norma. At the end of her life in this FX documentary, Norma came forward and said, actually, I haven't been anti-abortion at all. I was just paid really well by the evangelical church to be anti-abortion. And in that documentary, I might add, Norma says, very iconically, and I quote, "If a young woman wants to have an abortion, that's no skin off my ass. That's why they call it choice." R.I.P. Norma. All right, so, you know, this case is many years old, and I guess probably the question remains, why should I give a shit about it at this point? And the answer is you should care, because it's still being attacked today, and there's kind of the looming specter of Roe v. Wade being overturned pretty much every year, and especially now that the Supreme Court has had the addition of 2 conservative-leaning justices, that means that Roe v. Wade is more at risk than ever before. Whichever side of the issue you're on, it's still important, because again, it's constantly in public discourse, and there has never been kind of a resolution to this, whether abortion should be legal or not. And so it's going to continue to be an ongoing issue, and it's something that I think any informed citizen should at least have some background knowledge in. All right, that's it for me today. Thank you so much for getting ready with me. I hope that you found this entertaining and informational. All of the products that I use today will be listed down below. Again, please don't drag me in the comments. I am not a makeup artist. This is just what I do in the morning to make my skin look a little clearer and my face a little more youthful, okay? So if you liked this, if you want to see more, if you have cases that you want me to explain, please comment down below. I would love to hear, and I would love to dive into some more cases and get ready with you in the future. Thanks, bye! Excuse me.